we've had many privacy platforms about issues relating to either the data protection package or, let's say, surveillance by law enforcement and security authorities. That's always been a very popular topic. And today I wanted to address a slightly different topic, and it's actually relating to how how the data protection laws will work in practice, because we've been approached during our work on the data protection package, we've been approached by many lobbyists, many corporate lobbyists, but also, to a lesser extent, but also by people representing other sectors, notably sectors involving research, and people who are worried, and that will be our topic for today.
What we are seeing is, of course, that there's quite a lot of concern of citizens around the use of their personal data in health and well-being settings. 7 out of 10 citizens are concerned about how companies in this context are using their data. 92% of them are even worried about mobile health apps collecting data without their consent, or at least feeling that this is without their consent. So these citizens' concerns are significant. And at the same time, we're also seeing a lot of pressure on initiatives that where you use innovation to improve health in terms of quality, but also to make health more sustainable. And that basically needs a lot of data.
When you look at earlier privacy documents from the OECD, from the Council of Europe, you see in all those documents those exemptions. And they have all the same rationale that research is not about an individual, but about aggregated data, and that the privacy risks and privacy issues are less involved in such an activity. But very important, of course, is then that research will not, or the data will not be used to address the persons individually. So the research exemptions are justified because research is not about an individual, but about a group.
The data protection regulation can pose to historical research is that it can endanger the preservation of the sources for historical research. It can endanger the preservation of archives. That's why I'm talking specifically of the archives, the preservation of archives. By archives, I mean the documents created or received by a person or by an organization in the conduct of their affairs and selected for permanent preservation. As archivists, we're also suggesting that we can adopt a code of conduct aimed at balancing the protection of data subjects' rights, the protection of freedom of research, and the preservation of authentic records. The UK and Italy already have this kind of codes of conduct. Italy has a code of conduct both for archivists and for historians, and it has worked, I think, really well.
We've sort of used the word research throughout, but we haven't actually taken a moment to consider what it means and what the limited and specific activity that the word research represents. This is important when I look in a couple of slides' time in regard to what's rumbling around in the council at the moment. But essentially research is that phrase there, but it's about establishing facts, acquiring knowledge, and reaching conclusions. It does not involve direct action in regard to individuals. It does not involve making decisions or targeting particular actions in regard to individuals. And for the medical sector, for the archive as mentioned, and for the sector I represent, that has been supported by ethical codes that have additional requirements to prevent harm or other adverse consequences.